information. As I say, we provided his background information, which I restated here today. So he is employed, and has been for some time, and he has.
Okay, so first of all, let's back up a second. I don't have any results from any testing that he has allegedly done. Let's make that clear. You're telling me that I don't have anything. I mean, from this side, counsel, understand, this looks like he didn't go to community corrections, hasn't tested, hasn't done anything.
Well, I don't disagree with that, except that he did contact community corrections after the matter was in warrant status and attempted to get enrolled with them, and they told him they were not able to process him because the matter was in warrant status. He also voluntarily appeared. He didn't wait till today's date. He came in early to present himself to try to address the situation.
Your name, sir?
Jonathan DeHaye.
All right. Go ahead. What are we doing?
There was a matter of a bond violation that was issued. Apparently, my client presented himself on November the 27th. We appeared before the magistrate. He was arraigned on the warrant. There were certain bond conditions that were set, one of which was to check in with community corrections and register. He was also to enroll in a drug testing program. Apparently, there was some confusion about the community corrections contact portion, but he did enroll in a drug testing program. He was allowed to test in Macomb County where he lives, and but apparently did not.
Who allowed him to test in Macomb?
I'm sorry. I didn't hear you, Judge. I'm sorry.
Who allowed him to test in Macomb?
That was the magistrate indicated that at the time of the arraignment. She said he made a test in Macomb County.
Testing.
He enrolled at a place called Adapt in the city of Warren, and he did.
Do we have any results?
He submitted the one test there. I don't have any results, but I did have verification from the place that he did in fact sign up for testing there. Once it was brought to our attention that he had failed to contact community corrections, he did then call community corrections to try to enroll. They told him because the matter was in warrant status, they couldn't address it. We'd have to deal with the court. He turned himself in for immediately or shortly after finding out about this. He presented himself last week to the jail and was told that he'd have to address the issue today because today was his court date, probable cause conference. So I don't think there was any part on Mr. DeHaye's part to not comply. It was just a matter of some confusion on his part about contacting and meeting with community corrections directly. And I think he is 32 years of age. He is steadily working. He does have a young child he supports. As I say, he did voluntarily appear both.
Does somebody have the test result? Where he's testing? He didn't do anything. He didn't go for intake, nothing.
I went to.
He didn't go to corrections, but he did enroll in a testing program, and he did attempt to make an appointment to go to community corrections, but the matter was already in warrant status. So he did appear, as I said, voluntarily, both in November and in December, on learning of this warrant. So he's not. I don't think he's trying to deliberately avoid any responsibility, Your Honor. And if given the opportunity, I do think he would comply. He does have counsel. He is anxious to address this matter. He asked the court to consider reinstating his bond. Thank you.
Salandi, before you explode.
Thank you so much, Your Honor. Your Honor, the people are going to request that the court review the bond decision made by the magistrate in this case and find an abuse of discretion. The facts alleged in this case are, first of all, that this is already my third offense.
Can I just say, you're saying on the original one? Go ahead. Yes,
the original one, but I understand the bond has been denied right now, but the conditions ordered by the magistrate, the people feel were an abuse of discretion and were not sufficient to ensure public safety. This is an alleged OWI third offense with an alcohol BAC of 0.120, cocaine and THC were also present in the defendant's system. I think if I didn't already say there was a crash, and his priors are from 2017 and 2021. people would request that he have at least intermediate, if not strict supervision from community corrections, as well as an alcohol test in place prior to any release.
Anything else, counsel? I
Well,
mean, is he in a treatment program? Or is he just testing?
it was just testing. That was all he was ordered to do at the time of the arraignment on November the 27th. And he's working. He supports a young child. He's, as I say, he turned himself in not only on the original warrant, but he turned himself in voluntarily as soon as he found out that there was a violation. He immediately turned himself in, and the communication that I received from the court was either he has to turn himself in or they'll address it at the time of the probable cause conference, which was today. He turned himself in as soon as he could, which was turned out to be last week, and he's been in jail for the last 6 days. So I don't think there's any attempt on his part to try to avoid his responsibilities here.
Right, but counsel, I'm not clear how we got a PR out of the gate if the allegations are even near true.
Well, he is charged with a OUIL 3. That is true. That was known to the magistrate at the time. We presented information about his background as I've done here today. And the magistrate's the one that set the bond conditions. So I'm not sure. There was nothing unusual about the case, that there was no injury involved in the case. It is still just the 5-year max. So I don't think there was anything that the magistrate was not aware of under the circumstances, certainly from the face of the file or any additional information. As I say, we provided his background information, which I restated here today. So he is employed, and has been for some time, and he has.
Okay, so first of all, let's back up a second. I don't have any results from any testing that he has allegedly done. Let's make that clear. You're telling me that I don't have anything. I mean, from this side, counsel, understand, this looks like he didn't go to community corrections, hasn't tested, hasn't done anything.
Well, I don't disagree with that, except that he did contact community corrections after the matter was in warrant status and attempted to get enrolled with them, and they told him they were not able to process him because the matter was in warrant status. He also voluntarily appeared. He didn't wait till today's date. He came in early to present himself to try to address the situation early, and they said because there was no bond that was issued with the order, that he had to sit there, and has sat there for 6 days. So he has obviously suffered some penalty.
Where are the test results?
Your Honor, I don't have them with me. I
I'll
don't
tell you
have
what,
test results.
before I do anything, because you're just going around in circles, you're telling me all of this stuff, but it doesn't make any sense to me because I don't have any test results. You're telling me he contacted community corrections after he's in bench warrant status. I have someone that's obviously a user. I don't have any testing whatsoever, never reporting to community corrections. In my opinion, that poses a danger to the public because I don't know what he's doing. He's not in any treatment. He's not in anything.
Well,
So I'll give him a bond.
doesn't the file reflect that he was allowed to test in Macomb County? Because she put that on the record, the magistrate did.
But I don't have the results.
I
Follow
understand.
me here.
I
He
understand.
still would have to go to community corrections. He could test then in Macomb County. He has to sign a release. Those results get sent to us. I don't have any of that.
Understood. I'm simply asking, would the court allow him to be discharged, be released on a bond? He can report to community corrections before he's released
Tell
from
you what I'll
jail.
do. Because I honestly, counsel, you're not hearing me. So maybe somebody can figure it out. I'll set his bond at this point. I'll give him a bond. I think he's entitled to a bond now that he's appeared, albeit however he's appearing. I'll set his bond at 50,000 cash surety. I'll consider looking at that if somebody can provide me test results and I can set adequate conditions in regard to his supervision. But other than that, I'm not doing anything else.
Your Honor,
Yes, Ms. Lundy.
could the court consider at least a 10% provision on that bond? I mean,
What?
would the court consider at least a 10% provision or something? Maybe.
No. You're just not following this at all.
I'm following that he went from a personal bond to now a $50,000 cash surety bond, and I don't frankly understand. He's voluntarily turned himself in twice in this matter in less than a month's time. And I know the court doesn't have any.
That's the fourth time you told me that. I get it.
But it's a substantial bond modification. And
Ms. Lundy.
Thank you, Your Honor. If the defendant is released, will that be with a SCRAM alcohol title be able to
Yes.
post a $50,000 bond? I'm so sorry, I didn't hear the court.
Yes,
Thank you.
it would be with a SCRAM tether and intermediate supervision through community corrections. So what I'll do, in fairness to your client, counsel, because if those results are out there, you can get a document from him to get the results so that I can have the results, and I may consider something else regarding his bond, or I may not. But I'll give you a week to get that. I'll just adjourn this out 1 week to the 26th, and we can see what we can come up with. If I don't have any testing, I'm not changing.
Your Honor, can we schedule this matter for an exam?
Is all discovery complete?
Yes.
I didn't hear your answer.
Yes, it is. I believe it is.
People have their witnesses available in a second.
We'll try, Your Honor.
Preliminary examination in person, January 2nd, 2025 at 12 noon. That's before me.
Thank you. Your Honor, just one more item on this.
I'm sorry?
Sorry, I just had one more question regarding the DeHaze matter.
Sure.
Is the court? Did the
He's
court
not
say,
here anymore. He's been taken back, but go ahead.
okay, procedurally, did the court say it would entertain a request for a bond or review the bond again upon presentment of some information regarding the testing?
I need to see that he's testing. You're
Okay.
telling me he was testing.
Right.
I don't see it.
Thank you. I'll see what I can come up with. Thank you.
This hearing ultimately came down to one issue: credibility backed by evidence. The defense argued that the defendant attempted to comply with court orders, voluntarily surrendered, maintained employment, and supported his family. The prosecution focused on the seriousness of the underlying allegations, including a third offense OWI charge and concerns about public safety. But for Judge Simpson, the deciding factor was simple: there were no test results available to verify the defendant's compliance. As a result, the court imposed a $50,000 cash surety bond, ordered SCRAM alcohol monitoring and community correction supervision, and made it clear that any future bond modification would depend on documented proof. This case is a powerful example of how courts often prioritize verifiable evidence over verbal assurances, especially when public safety concerns are involved. Now we want to hear from you. Did the judge make the right call? Or should the defendant have received another chance based on his voluntary surrender and explanation? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Have you ever wondered what happens when someone tells a judge they followed the rules, but can't prove it? This courtroom hearing is a perfect example of why evidence matters more than explanations. The case centers on Jonathan DeHaze, who appeared before the court after being accused of violating the conditions of his bond. His attorney argued that the situation was nothing more than a misunderstanding. According to the defense, Jonathan had enrolled in a drug testing program in another county, voluntarily turned himself in when he learned about the warrant, held a steady job, and supported his young child. They insisted he had no intention of ignoring the court's orders and simply became confused about the community corrections process. But from the very beginning, the judge wasn't convinced. The judge repeatedly asked one simple question: where are the test results? Despite the defense's lengthy explanations, no documentation was presented to prove that the defendant had actually been complying with the required testing. Instead of accepting promises and verbal assurances, the judge focused on hard evidence. Without those records, the court had no way of knowing whether the defendant had remained sober or followed the conditions of his release. As the hearing continued, prosecutors raised even more serious concerns. They reminded the court that this wasn't a first-time offense. The defendant was facing a third OWI charge, and prosecutors stated that alcohol, cocaine, and THC were allegedly found in his system during the incident. They argued that releasing someone under those circumstances without proper supervision could create a serious risk to public safety. The defense continued to emphasize that Jonathan voluntarily surrendered instead of running from the warrant. His attorney repeated several times that he had cooperated with the legal process and wasn't trying to avoid responsibility. However, the judge made it clear that voluntary surrender alone wasn't enough. What mattered most was whether the defendant had actually complied with the court's orders, and there was still no evidence proving that he had. At one point, the judge appeared frustrated because the same explanations were being repeated without answering the court's main concern. The issue wasn't whether the defendant claimed to be testing. The issue was that nobody could produce the actual test results. Without those records, the judge explained, he couldn't determine whether the defendant had remained sober or whether the community was being adequately protected. In the end, the judge reached a balanced but firm decision. He granted the defendant a bond, but set it at $50,000 cash surety. In addition, if the defendant was released, he would be required to wear a SCRAM alcohol monitoring device and remain under community corrections supervision. The judge also gave the defense 1 week to obtain the missing test records, explaining that if verified evidence of compliance was produced, he would consider reviewing the bond conditions again. This hearing sends an important message about how courts operate. Judges don't simply rely on good intentions or persuasive arguments. They rely on facts that can be verified. Even if someone appears cooperative, missing documentation can completely change the outcome of a hearing, especially when public safety is involved. Whether you agree with the judge's decision or believe the defendant deserved another opportunity, one lesson is clear. In court, evidence always carries more weight than excuses. Now we'd like to hear your opinion. Do you think the judge made the right decision by requiring proof before lowering the bond? Or should the defendant have received more trust based on voluntarily turning himself in? Let us know your thoughts in the comments. And if you enjoy courtroom breakdowns like this, don't forget to like, subscribe, and turn on notifications for more real courtroom cases.